In addition to my work in the Indigenous Persons Court, as well as criminal court caseload that I carry, I'm also involved heavily in child protection work. So it was that I read with interest the August 8, 2016 edition of Maclean's magazine, where their cover story was entitled, quote, "How a Legacy of Racism Could Doom Reconciliation." As part of the article, the following was written, quote, "The gap between Saskatchewan's Indigenous and non-Indigenous population is deep and troubling. An Indigenous child born today in Saskatchewan is 13 times more likely to be apprehended by child protection authorities than a non-Indigenous child in the province. Fully 83% of kids in care in Saskatchewan are Indigenous, a rate second only to Manitoba, where 87% of children in care are Indigenous." Now, not for a moment am I saying Ontario's situation is akin to Saskatchewan or Manitoba's, but I am concerned about whether the court, my court, is doing the best it can for Indigenous families involved in child protection matters. So, let me share another story with you. This is the story of Cathy, not her real name, but her circumstance plays out all too frequently in my child protection court. Cathy was 15 when she had her first child, a daughter. She had her second child when she was 16. Cathy's extended family had been involved extensively with the Children's Aid Society while Cathy was a child. Cathy had ongoing involvement as a child, and an open file on Cathy's mother was with the Children's Aid Society of Brant, even as Cathy gave birth to her first child. The Society wanted to ensure that appropriate supports were in place for Cathy, especially due to her young age and the Society's knowledge of neglect and the abuse that Cathy experienced growing up. Cathy had not had the benefit of positive parenting role modeling growing up. After Cathy gave birth to her first child, she lived at Grace Haven, a home for teen mothers in Hamilton, but she felt lonely and homesick. So she moved to her father's residence. But this failed miserably because Cathy's father declared, quote, "It was screwing up his life." Cathy, to her credit, appeared to form a bond with her two children, but there was a complete lack of support for her according to the Society. Cathy had no parenting model in which to fall back on, and she and her current boyfriend simply argued and fought too much. The Children's Aid Society began a protection application. It eventually came before me as a motion for summary judgment. A motion for summary judgment is where a court is asked to make a decision on a case without an actual trial. The Society's material was about an inch thick at the summary judgment motion. Yet, of all the paragraphs written about what was wrong with Cathy as a mother, only 4 paragraphs talked about her family history. Although the Society wanted me to make an order making Cathy's children crown wards with no access for the purposes of adoption on the summary judgment motion, I said no. Giving my reasons, I said the following, quote, "I have read then Assembly of First Nations Chief Phil Fontaine's speech of 2008, where he indicated some 27,000 First Nations children were living in state care. The accuracy of that figure has been challenged by many children's aid societies across Ontario. Even if that figure was halved to 13,500, that would still be an astounding number of children in care. It would represent more than the on-reserve population of the Six Nations, the most populated First Nations in Canada. I then went on to discuss the approach we took in the Indigenous Persons Court with First Nations offenders and how critical it is to understand their background and the impact of colonialism on their families. I then ordered a trial and said there were 3 triable issues in Cathy's case. 1, what was Cathy's background and how that did or did not prepare her to parent? 2. What resources, aside from the Children's Aid Society, were available to help Cathy learn how to be a parent? And 3. What time frame is realistic for Cathy's rehabilitation as a parent? I gave those reasons at the end of January of 2014. Sadly, 2 years later, and at the commencement of trial, Cathy agreed to an order for Crown Worship without access. Her children will now be adopted. Sometimes we learn more from our failures than our successes. I feel I failed Cathy, whereas Terry had the benefit of a circle where I could hear his voice and witness his pain. I never heard Cathy speak. I never knew her background. I did not appreciate all the obstacles that she'd had in her life. Without that discussion, how could anyone begin to formulate a plan to help her rehabilitate as a parent? However, I'm happy to report that we are now coming together as a group of stakeholders to create a protocol for conducting circles in child protection court. This will be an important advancement in the way we deliver services to First Nations families who are attempting to deal with the fallout from colonialism and residential schools and its impact on their parenting abilities. In addition to efforts to reform our Child Protection Court, I'm also pleased to announce that we continue to expand Indigenous Persons Court throughout Ontario. At the end of February, I've been invited to attend an opening of the Indigenous Persons Court in Thunder Bay. We spent some time helping that court and being recognized as a model for that court setup. I'm also proud of the fact that Cayuga, just down the river, will open its own Indigenous Persons Court later this year. I like to tell people we are the judicial equivalent of a teaching hospital. I suppose the reason that I'm so keen on the expansion of our court to different jurisdictions is the incredible opportunity that unfolds each day in our Indigenous Persons Court, where we give voice to those who have inspirational things to say.